My lord, I beg to mention item number 20, my lord. This matter may be listed.
Zero.
Yes, my lord. Hearing, my lord, hearing matter 2020, my lord.
Yes.
May be listed on 12th of March, my lord.
Why so long after? It's a 2011 matter.
Yes, my lord. The file has been misplaced, my lord. I have to reconstruct the file, my lord.
Chair of Swins released the matter 12th of March.
How did the partner? Oh, there is one partner matter. Item 2 maybe taken, my lord. 2.
32.
32.
Yes.
There is only partner matter in your lordship list.
Now, what do you want?
What
do you want? Huh?
Your lordship has heard me. The government is to say
Yes.
something. My part almost I have completed. I may add something.
May it please your lordship. With the consent of the other side, my lord, I beg to mention item number 31. We have been led by Mr. Kane Chaudhary, my lord, senior advocate. My lord, he is not available today. So let the matter come up on 12th of February, my lord.
10th.
12th.
12th of February.
31, my lord.
Yes.
My lord, there is an interim order that may be continued.
Next date of listing.
Much obliged, ma'am.
Lordship, prayer for listing. One BA filing number 86626, Lordship. By tomorrow, Lordship.
Maybe for this court. Earlier rejected.
No, Lordship.
Go to senior bench.
Act number.
With please, your lordship, I beg to mention item number 30. The matter kindly please be adjourned for day. The records are called for. They are still not here.
This year not received. List again on.
Much obliged, my lord.
Hmm?
It is 1,000.
1-4. Let it come up then, if it is.
That is good.
14. List again on.
May it
Very
please your
much
lordship.
past 30. Continue.
Lordship, I beg to mention item number 9, lordship. Kindly pass over for the day, lordship.
They did not receive. List again on. So.
Right, sir.
Fifth to দুদিন পিছত CD আহিব.
Lordship, not on 17, lordship. Can it be on 18, lordship?
Yes.
Like,
May I plead, your lordship? I beg to mention item number 10 for adjournment.
Is the matter on when?
Any date, lordship.
CD retain. Huh? Fixed है कोई?
May I please, Your Lordship? CD may be called for, CD will be requested. 21C.
CD.
Please, my lord. But this is related registered under NDPS, my lord. 21B, my lord. 27A is there, my lord. Lordship, call for CD, my lord.
Move.
My lordship, my date, my earlier date, my fixed, my lord. My lord, oblige, my lord.
May I please, Your Lordship. POCSO, my lord, case there may call for, and in the meantime, this is to the informal lordship. Notice, my lord,
Is to respondent number 2.
two lordship.
Steps by registered post within.
Throw police station, my lord. Notice, my lord. Throw police station. Oblige.
Beg the Lordship, my lord. First, my lord, I just want to draw your Lordship's kind attention with your Lordship's permission to page 12. Page 12. Which is the FR in connection with the Orang PS ZDA number 37 dated 8/12/2025. I'm just only reading out the relevant portion for your Lordship's kind convenience.
This is commercial quantity, isn't it?
Commercial quantity, my lord. And my lord, I beg to inform you that on 8/12/2025, at around 7:30 p.m., based on reliable input received by you regarding the storage of large quantity of suspected cannabis ganja at a residence of one Metisha Daimari, so-and-so, a general diary entry was made by Orang PS number so-and-so, my lord. Now, my lord, I just want to then again take your lordship to, I applied for, my lord, for bail, and my lord, my bail was rejected, my lord, and I just want to take your lordship to page 31, the last page. Page 31, the last para, my lord. Page 31, the last para. Only, my lord, reading out the relevant portion for lordship's kind convenience, my lord. The case diary has not sufficiently progressed and the investigation is in a very early stage, and therefore considering the early stage of the investigation and the nature and the gravity of offense, the instant bail application for accused Srimati Paguni Basumatri stands rejected at this stage to facilitate investigation, my lord. In this regard, my lord, I just want to place a very charismatic judgment of the Honorable Supreme Court, my lord. Gurjat Singh versus State of Punjab, 2025 SCC online, Punjab and Haryana 849. But I will just supply the copy to your lordship, my lord. Only, my lord, para 4, which is very important. I'm just reading the relevant portion. To put it shortly, a human attitude is required to be adopted by a judge while dealing with an application for remanding a suspect or an accused person to police custody or judicial custody. There are several reasons for this, including maintaining the dignity of an accused person, howsoever poor that person might be, the requirements of Article 21 of the Constitution, and the fact that there is enormous overcrowding in prison, very important, my lord, leading to social and other problems as noticed by this court. In inhuman conditions in 1382 prisons, 2017, 10 SCC 658, my lord. So, my lord, if allowed to go on bail, my lord, I will obey your lordship's any order. I will abide by your lordship's any restrictions. I will abide by your lordship's any conditions that will be imposed on me by your lordship, my lord. And my lord, I have got a son, my lord, who is with me, my lord, who is 7 years old. He has been missing his schools, my lord. And that is why, my lord, I just pray for bail, my lord.
Yes, you repeat your submissions on the day CD arrives. Yes.
My lord, highly obliged, my lord. Long date, usually. 26. Obliged, my lord. Highly obliged, my lord.
May please, your lordship. The regular bail application, lordship. POXO 6 is there, lordship, charge sheeted case, lordship. The TCI will be required, lordship, and notice to the informant.
And copy of TCR along with CDM. Notice to respondent number 2.
Pro learned PP, lordship.
Obliged.
This is also a POXO case, Lordship, search-sheeted case. PCR may be called for in notice may be issued.
Same.
Yeah, it is, Lordship. But it taken, notice was taken upon the respondent number 2, Lordship.
Granted additional PP, comma, upon instructions received has submitted that notice on respondent number 2 has already been served. None appears. Date known. Because the earlier notice says 22/1/26. The same notice that has been given, then that date is over. Because this is the notice that must have been sent to the police. This mentions the next date of hearing as 22/1/26. Doesn't mention any date. Doesn't even mention the court. Where will she go around? Guwahati High Court, Guwahati Principal Seat, outlying benches, Honorable Court of Dash, Special Judge, Session Judge, Additional Session Judge, District, blank, Assam State. Where will he go? Perusal of the turn. submitted by the OC of the concerned PS does not reveal any date of hearing or the court before which the case is pending. Hence, it is easily discernible that the number 2 as of today's date, or that the case is before this court. There is a mobile number. Hence, place the case again on so and so, learn it to inform who will you inform? The party directly? The learned PP to inform accordingly. You can either do it through police or if number is there. Want it back. You have copy? Give it at least the matter again.
Lordship, short date may giving Lordship.
How short?
Oblige.
May I please, can the matter may be passed over for the time being?
Did you receive? And after some time.
My lord, the cost title, my lord, I am to type as a district Morigaon. But unfortunately, my lord, there is typographical mistake, Kamrup Metro District. So, my lord, I may be allowed to say, correct the cost title. And I will file the corrected cost title, my lord. The case number is all right, my lord, no problem. Yes, police station is same, no problem. Special Judge Morigaon in the second page.
Can copies have of the TCR has been received?
Morigaon is the special judge. Morigaon. Police station is
It
Morigaon.
appears that no report has been received with regard to service of notice upon the respondent number 2. Await service. Learned counsel for the petitioner submits that there is a mistake in the cost title which needs to be corrected, and accordingly petitioner is permitted to file appropriate application. Is the matter again on?
Two. Oh, obligation. 12-2. Obligation.
Lordship, my senior selection code number 3. May kindly. Yes, there is no receipt, Lordship.
Did you not receive list again on?
Deeply obliged.
None appears on call. Perusal of the order sheet reveals that on earlier several occasions, none had appeared for the petitioner. Petition stands dismissed for non-prosecution. Up to date, statements are there. This is what? 15. Let us call up after some time.
May please, your Lordship.
Yes.
Lordship, pursuant to the order of the court, we have appeared. Moreover, Lordship, at page 17 is the FIR. There is no direct allegation against me. As this is the allegation, it's only on suspicion that I have a hand in forgery. Whereas in settlement cases, the branch manager is the last authority who signs.
What has the investigation found? What is the finding of the investigation regarding that forgery part? Has it been sent for forensic?
Recorded. And the most important part is that the claim is not settled. No monetary transaction happened. So the claim is under settlement. The claim which the disputed claim, therefore no loss has been caused. That is the most important. And I am not at all involved. The branch manager himself is involved. Now to save his skin, he has filed an FIR. Lordship, anyways, if Lordship FSL report will make it more clear. I have recorded my statement. Lordship.
About item 14, who is he? When is that case listed? 10-2. We will have this on 10-2. Interim order passed earlier. List the matter along with AB 2791/2025 on 10-2. Interim order passed earlier, shall continue.
Lordship, otherwise I have appeared twice. Lordship.
Did he be retained till then? Or what? Maybe FSL will come by then. You can send it back.
May I please, Your Lordship? Lordship, pass over the matter for time being, my lord. Simple.
Let him come.
Obliged, ma'am. May I please, Your Lordship? Lordship, this FIR is lost, Lordship, as a Lordship, TCR may be called for Lordship, because Lordship, here is Lordship 109 is there, Lordship, attempt to murder, Lordship. Lordship, this is a session tribal case, Lordship. So,
Submitted that CS has already been submitted by CS number. Call for the scanned copy of the TCR along with CD.
medical report may be also called for.
No need to mention separately, everything will be there.
Obliged.
May I please tell us? In this case, my lord, nothing against me in the FIR, my lord. Subsequently, my lord, during the course of investigation, in the charge sheet, one line is mentioned that the accused person who are arrested at that time, they would likely to deliver some materials to me. This is the allegation found during the investigation stated by one co-accused. This is the only allegation, my lord. Whether and CS was filed on 31/8 and I was arrested on 3/8, my lord. Whether on such footing should I remain in jail, my lord? I have been protected by the Tufan Singh, my lord. Since on such statement is, my lord, not admissible, my lord. Today is 179 days, my lord.
Which page of the charge sheet?
Charge sheet, my lord, I would like to place, my lord. Charge sheet, page 41. Page 41 of my petition, my lord. Charge sheet is there. During investigation, bill of facts recovered. And later to deliver to Manik Chandra Dev. In fact, not delivered.
Yes, PP. What is there? One of my lord. Stand on my lord. Of that. Yes, my lord, it is. Here. What is it? After. Point on that, yes. Mother-in-law, sister-in-law. Conversation is natural. Unless you have the contents of the conversation. Hmm?
This is filed, my lord, investigation over. Here analysis the matter of trial, my lord. Kullalu with Ahmed Arimutta judgment, 2022.
All right, he was arrested because he was implicated by the co-accused, but then Tufan Singh stands in the way.
Charge is yet to be framed.
You got the judgment?
Yes, my lord. Singh and Paulullah with Ahmed Arimutta. Arimutta judgment saying the CDR analysis is the matter of trial, man. Voices. Or one. There are 10, my lord, Arimutta judgment.
Learned counsel for the petitioner, learned additional PP. Application number so and so. As per the allegations contained in the FIR, two women who were loitering near Station Road, Neelam Bazar, district Sribhumi, were detained by the police on the basis of secret information, and from their possession huge quantity of, what is this, ganja or heroin?
Heroin, man.
Quantity of heroin was recovered from their possession. In course of investigation, based on the statements of the aforesaid two persons. Two arrested persons. The present petitioner has been arrested. The ground that the said contraband was destined to be delivered to the present petitioner. The two arrested women are the mother-in-law and sister-in-law of the present petitioner. It appears that the CDS called for has been received. Charge sheet has already been submitted.
One copy of TCR is received, my lord.
Submitted. From the above, it transpires that the basis of the arrest of the petitioner, submission of charge sheet against him is the statement of co-accused persons, as well as, no, not full stop, as well as CDR of the arrested accused persons, which revealed a large number of phone calls between the present petitioner and the other two arrested accused persons. View of the settled position of law that statements of the co-accused persons cannot form sole basis of conviction against of any accused person, as laid down in Tufan Singh versus State of Tamil Nadu, P1 4 SCC 1, as well as the decision in State by NCB, in bracket capital NCB, Bengaluru versus Ulullah Bid Ahmad Arimutta and another fellow. T22 2 SCALE scale 14. Wherein it has been held on the basis of the decision in Tufan Singh Supra, the arrests made by the basis of confession stroke voluntary statements of the respondents, the co-accused under section 67 of the NDPS Act cannot form the basis of overturning the orders passed by the High Court releasing the petitioners on bail. And that clear details of the accused an aspect that will be examined at the stage of trial, time of the view that the petitioner would be entitled to bail, inasmuch as in the present case also the petitioner has been arrested on the basis of the statements of the co-accused. CDR details may be noted that there is no record of the actual conversation between the accused persons. Also to be noted is the fact that the accused persons are relatives and therefore because there have been frequent calls between them, it would not be sufficient. To implicate the petitioner with the alleged offense. No recovery was made from the possession of the present petitioner either. In view of the above, as well as the fact that petitioner has been in custody since last 109 days.
179 days.
79 days. Investigation is also complete. The prayer bail is allowed. Be released on bail of rupees 1 lakh with 2 sureties of like amount. Turn it below. Provided that the petitioner shall participate in the trial if one commences, shall not try to the witnesses in any manner. Disposed of accordingly.
Obliged.
Which was the answer in the year 2012.
They appeared in January, I think 23rd of January.
This was the provided.
One Mr. J.C. Gogoi, advocate. Yes. The order of cognizance is under challenge here, is it? asked by the 14-year. There is also not there, oh, it's there. So 202 statements, there's directly taken cognizance, did not send it for investigation to the police. There's a reflection that if no instruction is received, matter will be taken up on its own merits. Yes. At least he should have come and said that he has no instructions. Challenge was with regard to jurisdiction. The cause of action took place in Lakhimpur. Case was instituted in Guwahati. Yes. It's clear from section 202 that the complainants and the witnesses present have been examined. Investigation is to be directed by the police. Here, straightaway cognizance has been taken. The face of it, the order is bad. But I think we'll dispose of this instead of keeping it pending again. Chamber deed of asylum.
Please, Lordship. Taken up after some time.
Time.
Arguing council export of
Hmm?
Arguing council export of
Hmm? Right, let's have it on Thursday then.
next week, my lord.
Next week. Prayer of Learning Council for the
10th or 12th. Public.
Lordship, TCR was called for Lordship. That's received TCR.
Yes.
Here the allegation is that Lordship, the FNM accused number 1, 2 and the present petitioner Lordship. There's the allegation that they slaughtered out a horse Lordship and the meat of horse mixed up with the meat of beef Lordship and sold in the locality. That is the allegation Lordship. Petition number 1 and 2 already arrested Lordship and subsequently charge sheet submitted. Showing the petitioner.
Who is arrested?
Lordship, petition number 1 and 2 Lordship. I have also annexed, page 12 is the forwarding of FNM accused number 1 and 2. That is Afzal Haq and Shohidur Rahman Lordship.
What is your role attributed?
Lordship,
You are selling.
no Lordship, there is no specific Lordship. Can you see the affair Lordship? Basic allegation Lordship against accused number 1 Lordship, 1 and 2 Lordship. And he is an inhabitant of Lordship in different village Lordship. They belongs to Lordship in particular.
What
village.
made you steal a horse? You were going to steal a cow. Why a horse?
Lordship, that's peculiar Lordship incidents.
That horse and they mixed up their.
Yes, that is what I'm saying. Where is the need to steal the horse? You could have stolen a cow and mixed directly. What is the material against the present petitioner, Tara Mia? A fit case for pre-arrest bail. Learned counsel for the petitioner and learned addition. An application under allegation against the present petitioner is that he, along with 2 other accused persons, have already been arrested, had stolen the horse of the informant,
Subsequently charge sheet submitted.
and mixed it with beef and sold it in the market after slaughtering the horse. Charge sheet in the case has been submitted. Perusal of the PCR. There appears to be and material implicating petitioner, and having regard to the nature of the allegations, the present is not considered to be a fit case for grant of pre-arrest bail. The therefore pre-arrest bail is rejected and the petition stands dismissed.
Published.
May I, your lordship? Lordship appeal against conviction, lordship. Appellant was convicted under section 436 of the IPC and sentenced for a period of 1 year, Lordship. In this case, Lordship, there is a no eyewitness, only on suspicion. As I
Before we
have,
go there, tell us the facts.
Lordship, your Lordship, kindly have a look at the Azahar at page 3 of my of the paper book, Lordship.
Yes, what is your submission? You were
Lordship,
caught red-handed, basically.
no, Lordship, actually, Lordship, is it a believable story? He suspected that Lordship, he may be involved. But it
No,
is a
he was seen running down from the tilla. What were you
Lordship.
doing in the middle of the night there?
Lordship, is it a believable story? A person, after setting fire, remains stay for
He wasn't
sometimes
staying, he
there.
was running away.
But Lordship, is it possible?
Why not?
Immediately after setting fire, no one
What? He will
could,
sit there to take warmth from the fire.
no. Is it possible
What?
to remain there for some
He
time?
didn't remain.
Why, Lordship? But how he will remain? A person committed
He made
crime.
sure that the fire erupted and then ran.
Lordship, whether and your Lordship kindly have a look at the statement of the accused. While his statement was recorded under section 313, Lordship.
Yes, what did he say?
Lordship.
His statement cannot exculpate him, but what is the explanation given? Anything is there?
Lordship.
Where is that in the paper book?
Lordship. It is at page Lordship 16. It 16, Lordship. Last question. Do you have anything to say? Answer, I went there to help the extinguishing fire. I had not other intention, nor I had set fire. This is a false case. And in his cross, Lordship, all along he stated that he went there to extinguish fire, and they, purely on suspicion,
Who's cross? He gave DW.
Lordship, PW Lordship. Lordship, kindly have a look at the evidence of PW 4, page 13. He suggested it is not a fact that Hashimuddin also came to the PO for extinguishing fire, but out of previous grudge, he has been kept confined and handed over to police. Ezahar lost after 1 day. Incident of 12, Lordship, it is incident of 12/8/6 at 3 a.m. and Ezahar lost on 13/8/2006. There is every possibility of concocted story in the Ezahar. He went there and there is a dispute, Lordship. That's why they suspected. There is no eyewitnesses. And moreover, Lordship, informant who is not the neighbor of the Lordship PO. So he while the whole house was gutted out, Lordship, then informant and other came to know. Whether it is a believable story that accused person after setting fire and while the whole house was burned, he left the PO.
What else will he do?
Lordship, he after committing crime, immediately he will leave there. This is expected behavior, Lordship. A person committed crime, he will not remain there for long, Lordship.
Where is that evidence that he remained there for long?
Lordship, after gutting the whole house, Lordship, it is the Lordship evidence of PW1 that he has seen. But Ezahar was lost after 1 day. There is every possibility of tainting the Lordship, making a story, Lordship, just to implicate the present appellant, Lordship. Lordship, also have a look at page 14, evidence of PW5. Defense
is the
suggested, Lordship, page 14.
FIR.
Lordship. Page 3, Lordship. May I read, Lordship? Humble submission is that around 3 a.m. on 12/8/2006, I saw my brother Muhammad Safiquddin Laskar's house had caught fire. Then I was rushing to my brother's room from my house. I heard a scream. At that time, on seeing my co-village, Muhammad Hashimuddin, coming at a run from my brother's room and descending from the hillock, I caught him and saying him that we should douse the fire. I took him to the house and tried to douse the fire. At that time, Hashimuddin did not try to extinguish the fire and kept standing there. This story is it also a believable story? Person committed crime he was remained standing there. After the incident, he was apprehended. After the incident, he was apprehended, Lordship. I suspect that accused Hashimuddin had tried to flee from there after igniting the fire to the house. In this incident, all the articles of the house, including the goods shop, got burned and there was a loss of rupees, about 3 lakhs. It is worth mentioning that there was a dispute with Hashimuddin over a matter of road. 2 houses, including ducks, fowls, and goats, were completely gutted in the incident of fire. So it is very clear that informant and other witness came to know about the occurrence while the whole house was gutted, Lordship. Not at the immediately after the occurrence. If it was there, they can try to extinguish at the very initial stage. And accused, Lordship, after committing crime, how you will remain there? And it is from the cross, Lordship. And Lordship also kindly have a look at the evidence of PW1. In his statement, in the Azahar, he stated that on suspicion, Azahar lost against him, but he developed story in the Lordship while deposing before the learned trial court. Lordship, kindly have a look at the evidence of PW1. May I read, Lordship? I know the accused Hashimuddin Lashkar. The occurrence took place about 4 years ago. On the night of the occurrence, I was in my house. My house is at a distance of about 20 knols from the house of my brother Shafiquddin Lashkar. Due to earthquake on the night of the occurrence, I awakened from sleep and saw the house of my brother Shafiquddin Lashkar on fire. I then ran to the house of my brother Shafiquddin. On the way, I saw accused Hashimuddin coming down from the house of my brother Shafiquddin. I caught Hashimuddin and took him to the house of my brother Shafiquddin. And after taking him there, he was remained standing there without extinguishing fire. This aspect is whether believable. He was also not tied with. Subsequently, he was handed over to the police. My nephew Ainal Jamir Ahmed and my son Jalil Ahmed, who were in the house.
There is no suggestion in your cross of PW1 that he was not running away.
Lordship, police recorded about 1 year after the occurrence. House of my brother Shafiquddin. It is not a fact that I did not state to police that my nephew Ainal Jamir Ahmed and my son Jalil Ahmed told me that accused Hashimuddin set fire. This aspect was developed. There was a dispute over a path between myself and the accused Hashimuddin. I cannot say as to what is written in the FIR. It is not a fact that due to dispute with the no such suggestion is there to the accused, Lordship. But that may be, Lordship, but from the totality of the Lordship circumstances, whether it is a believable story. Why there is a delay of lodging 1 day, Lordship, Azahar? It is an incident of 3 a.m. of 12A and Azahar lost on 13A. There is no explanation why there was a delay. Moreover, Lordship, IO was also not examined in this case. Purely on suspicion, Lordship, case lost against him after 1 day of the occurrence. There is a dispute.
Yes. That is all.
Lordship, 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 kindly come to page 23. Finding recorded by the learned. Page 23. Internal page 7, Lordship. The circumstances which was against the accused appellant. Immediately after the fire was broken out, accused person was seen by all the witnesses PW 1, 3, 4, 5 to flee from the place of occurrence. PW 1, Sharafuddin Lashkar apprehended the accused Hashimuddin, noticing him to come down from the house of the Shafiquddin, which was burning at that time. His suspicious presence at the late hour of the night at the PO and his attempt to flee from the scene of occurrence immediately after the fire was broken out. Attempt of the accused to suppress the actual reason behind his presence. His plea of going there to help the extinguishing the fire has been proved false. It is also evident that there was a previous enmity between the parties. So, Lordships, regarding the finding of number 4, Lordship, he was there even after extinguishing the fire.
Was there, he was kept confined. That is why he was there.
It is after Lordship extinguishing fire. He was confined, but before that he was there.
Before that, he was caught and taken there.
No, Lordship, but he was also not tied up, Lordship, but he was remained there. He was remained there, not tied up, remained there till it was extinguished. That aspect was not considered by the learned trial.
Not in a position to go anywhere.
But how? He was there, everybody is busy with the extinguishing the fire. He can, Lordship, conceal himself. Again also, Lordship.
He has been discovered. What is the point of concealing himself?
But discover maybe, but he can conceal at the relevant time, Lordship. If that was
Yes.
and the Lordship, he was sentenced for a period of 1 year, fine of rupees 3,000. Lordship, consider, and he was arrested during investigation, Lordship.
Whatever, quite lightly, I think. Causing a loss of more than 3 lakhs and then.
That,
a fine of
but
3,000.
whether prosecution is able to establish their case, Lordship. First, delay was no way explained. Why it was after 1 day. Lordship, he was assuming that he was red-handed. Why Azahar was lost after 1 day? This story is believable. That means immediately after the occurrence, he was not red-handed. That's why Azahar was lost the following day of the incident and accused was handed over to the police. Whole prosecution story belied by this fact, by losing the Azahar at the belated stage. That belied their story that he was red-handed at the relevant time. Where was the accused for 1 day? It was in their house or in the police station. That aspect was not brought by the prosecution before the learned trial court, and learned trial court also did not deal with that aspect, Lordship. Either he was confined for 24 hours in the house of the informant, or he was free. Lordship, my another submission, Lordship, whatever evidence is adduced by the prosecution that fails to establish the guilt of the accused. There is a possibility of alternative hypothesis, Lordship.
I think it was FIR was lodged on the following morning itself.
But it is 13, Lordship.
Maybe it is 13. He took place, said that in the night of 12/8 occurrence took place.
Lordship.
After 12 o'clock, it is technically 13th, but
Lordship. But it was
that means actually the occurrence took place on 13th itself, and the FIR was lodged in the morning. His evidence is there. I became sick, and my brother Sarifuddin on the following morning informed the matter to the police by filing FIR. Yes.
I'll leave it to your Lordship.
PP.
Lordship.
Incident Manu, what the people to Manu save this. Oh my lord, he was coming from the place, my lord, where the fire was. My lord, making any circumstances. 19 in
Yes, yes. That's
Nine of the
I know. Yes. Yes.
clear evidence of personal so much that I don't know, but you make
Maybe.
Lordship, in reply to my learned friend's submission, one thing may I point out, Lordship. While Azahar was lost by the informant, he now here stated that PW Lordship 3, 4, and 5 has seen that accused appellant ran away from the place of occurrence.
That they know.
But Lordship, it was not stated. The basic fact should disclose it.
That
The
is-
Azahar.
that
At
is-
least,
that is
at
what
least
you are
some
talk-
person has seen.
what you are talking about is the evidence part,
And
not
Lordship,
the basic fact. Basic fact is that he was seen running down
but
by
if,
the informant.
Lordship, other,
Whether 10 other people may have seen it, but that is not the concern of the informant.
and that is
He will
true.
write what he saw.
That is true. But Lordship, that aspect was also even not stated before the police while his statement was recorded. Lordship, kindly have a look at the suggestion at the paper book, page number Lordship 9 to the PW1. Lordship, kindly have it. It is not a fact that I did not say to police. That could not be confirmed as IO was not examined. So evidentiary value, Lordship is aware how much evidentiary value. That could not be confirmed as IO was not examined, and accused lost a chance to cross-examine the IO also. This part was not stated by the informant to the IO also.
That plea should have been taken there.
But it was taken, it was suggested to the PW1 in his cross-examination. He denied, but that could not be confirmed
Why was
by,
the IO not examined?
cross-examining the IO. IO was withheld by the prosecution side for the reason best known to them. Page 9, Lordship. Cross part, third para. It is not a fact that I did not state to police that my nephew, Ainal Jamir, and my son, Jalil Ahmed, told me that accused Hashimuddin set fire to the house of the Shafiquddin.
And that's a different matter. It's regarding the seeing him running away, that part. May not have told that way. That's a different.
But Lordship, evidentiary value, while their statement was recorded, it was not stated to the IO. That aspect Lordship may consider. All right.
Please, Your Lordship. My senior is in Lakes, Your Lordship, kindly met.
What do you want?
Time, Your Lordship, kindly matter may be take.
Read your sentence, please. So may be taken up when?
After 2 weeks, Your Lordship.
The prayer of learned counsel. Talent fighting personal difficulty of senior counsel is the main on it.
Yes, Your Lordship.
Please.
Yes.
May it please be, Lord. Facts of the case, my lord, as disclosed at para 2, my lord, page number 3 of our appeal memo. My lord, what happened? One Deepa Devnath was the first information report alleging inter alia that on 22/2013, her husband, Yvonne Devnath, called for by the Porimal Devnath and Porimal Devnath and called to the outside to the gate. Porimal Devnath and Jodu Devnath. And thereafter it is alleged that the husband of the informant reached the gateway and then the accused appellants assaulted her by boxing and otherwise assaulted. And then she taken her husband to his residence and kept sleep in the bed. And thereafter on next dates, that is on 21/2/2013, her husband died. That is the facts, my lord. And thereafter he informed the nearest residents and all the persons attend there, along with the Gaungura VDP secretary, etc. And thereafter lodged an FIR before the OC Goreswar police station, and accordingly a case was registered under section. The case was registered. Goreswar PS case number 2013 under section 302/34. Once the investigating agency started investigation, and after investigation, charge sheet has been submitted against the accused person under section 302 IPC. And what happened thereafter during trial, the learned additional session judge found that there is a charge frame under section charge altered by learned additional session judge to 3041/34 IPC. And accordingly, trial was held, and during trial, as many as 9 witnesses were examined, including the doctor and IU, my lord. And thereafter, the learned additional session judge FTC Rohingya found that there is a case under section 323/34, my lord. And accordingly, he was convicted to 1 year and fine of rupees 1,000. My lord, from the evidence, if your lordship go to the evidence on record, your lordship will find that so, my lord, except Deepa Devnath, the first informant, wife of the deceased, the other witnesses are all here.
Yes.
Though Deepa claimed to be the eyewitness in this case, that has not been proved, my lord. My lord, she deposed in her evidence that her husband was called for by the accused appellants, and then deceased husband went to the gateway, and thereafter the accused persons assaulted him by blow, etc. and other, not by means the weapons. And thereafter she took her husband to the residence and kept her in the bed and for sleeping. And when in the morning she tried to She tried to woke up her husband. He did not respond, and therefore, after some time, she came to know that her husband, in fact, died. And then she informed the nearest people, and thereafter lodged a first information report. The accused appellants, my lord. So, my lord, my respectful submission before your lordships that evidence on record, your lordship will find that the learned court below directly convicted the accused appellant under section 323/34, my lord. Investigation they were also in jail, my lord, some days. Okay, sir. Okay, sir.
Ultimately, only 323.
323/34, my lord.
You're lucky.
Lord,
You're lucky.
our respectful submission at this belated stage, all pending case, my lord, that too under section 323/34, my lord. And in the meantime, the accused person were in jail for some days. Considering those aspects of the matter, maybe this appeal may be allowed, my lord.
Yes. Who is appearing? With Porimal with for what enhancement? This criminal appeal, item number 27. Yes. Yes. Cannot wait forever. Are you going to start? Yes.
No.
We have already heard that story and the learned trial court did not disbelieve you. But only question here is whether it should have been a higher offense. So make your submission, confine your submissions to that extent. Problem is, even you did not take it seriously. You did not take him to the doctor immediately because you thought it's nothing very serious. I mean, he was already dead. Yes, that is all.
But she is the only sole eyewitness. Her evidence did not support by the other evidence, my lord. But all other witnesses, out of 9 witnesses, all are hearsay. Immediately after the occurrence, she did not inform to the neighboring residents that he was assaulted by the accused persons.
But she took it as a
And thereafter,
small
he
fight.
did not take
That is
any steps to treat her husband.
all. Shabby. Hard learned counsel for the petitioner. Both cases you write. No? Appellant. And additional PP also. Counsel appearing for the government. KV. Pardhead matter, no?
Must have.
Pardhead matter তো আছিল নহয় তেতিয়া আগতে।
Must.
But this section 50,
Listen.
so section 50 may be attracted in the sense that matter PW 5 says the constable that the alleged narcotics was recovered from the bag of the accused. That is, it must be vanity bag. So, from a physical possession. There is then matter section 50 would be attracted. But to reply an authorization, how he was authorized, how he informed the higher officer in writing or simply saying before the court.
Either my lord. My lord, the proceeding is but it is in the day hour, my lord. That entrusted the duty. What is there or not? That, my lord, in the it is also stated. Earlier, my lord, some my lords. Part is that, my lord, there is of the my lord contract. Because, my lord, it is the matter is of my it is that part is not a.
Regardless of whatever is in their CD, we have to go by whatever has been produced before the court. You may have complied with 52, you may have collected also, but unless you produce the samples, neither the bulk nor the sample. See list of exhibits, Caesar list, ZDE, Azahar, report, forwarding report, sketch, charge sheet. The whole basis of the case, the material that is not there.
Of that, my lord, again, my lord. That is, my lord, the mandate, my lord.
The very basis is not there. Either you have to produce the entire bulk or you have to go through 52 and produce the samples. All right, CAB.
Apply, madam. In fact, the Caesar itself is there only. There was no Caesar itself. Thank you.
Please, Lordship.
All right. I'll run it counsel for the petitioner.
Lordship,
Huh?
is a matter, actually, 2 years back, it was prepared, LCR received. And so many dates taken by the opposite parties, Lordship. And 3 years completed, he is behind the bar. That's why, Lordship, it should be disposed as soon as.
This was made part heard before.
Yes, part heard many times they have taken.
No, no, not before me.
Then at the last time, after 6, 7 times, they could not argue the matter. Then the Honorable Court released from the part heard. And if we go through the history, Lordship, there are so many dates already given. And some order it is written that this is the last opportunity given to the opposite party. So, Lordship,
where is the impugned judgment?
Judgment is, Lordship, next one, page number, Lordship, 14. Sorry, 17, Lordship.
What is this High Court judgment again?
High Court judgment is not there. This is the first time we have appealed.
This is some other judgment.
Yes, Lord.
By saying?
Yes, Lord. Yes, actually case was fixed for final hearing, but colleague he is not able to argue for the final hearing, and finally he argued for the I. But this LCR received in the same year in the month of November, October, I think, 2025. 2026, it is 3 years completed. He is behind the bar, Lordship. I will not be accepted. It is court declared before, because LCR received I have provided so many judgment also, Lordship. Section 43 and 42 did not comply, Lordship, by the police officer.
Not complied,
Lordship.
no communication.
No communication is not, Lordship. Teaser and SARS.
All right, next Tuesday, you be ready.
Next Tuesday date. PLP is better, Lordship.
Prayer of learned additional PP seeking time to go through the record. The matter as a fixed item on 10.
Lordship, 12 or 13, Lordship. 10 is.
All right, 12.
Okay, Lordship. Lordship. Would be the last chance, Lordship.
Yes, I remember. I am here on 12.
All right, Lordship.
May I please, your lordship? I have been convicted for an offense under section 370 subclause 4 of IPC passed by a judgment of Section Judge Lakhimpur dated 31st January 2025, your lordship. And I was sentenced for rigorous imprisonment for 10 years with a fine of 5,000, and in default of the fine, simple imprisonment of 6 months, your lordship. I am in judicial. I am now convicted person, and in the behind the bars, 18 months, 1 year and 8 months completed before behind the bars, your lordship. And it is a criminal appeal number 40, 2025, lordship. And there are 12 witnesses examined by the prosecution side in the lower court, London lower court. Neither of the prosecution witness stated that they have seen that I have trafficked a minor girl, and even my name is not mentioned in the FIR even. And the person who lost the FIR, namely Nur Islam, the another co-accused, co-accomplice, he has been absconding from the very beginning of the trial procedure. He's not been arrested, not even arrested by the police. The police unable to arrest the person who has lost the FIR. Without being present, being appearance of the A2, namely Nur Islam, I was convicted, and the prosecution or the police side unable to make him appear before the honorable court, face the trial. And without the appearance of Nur Islam, the FIR lodger, actually the father of the victim, your lordship, and subsequently, even though the A2, the accused number 2, lost the FIR before the Laluk police station, stating that on 28 June 2018, his minor girl was missing